All right, good morning. Welcome. It's good to see you all here. My name is Kelly Swartz. I'm the Director of Legal Services for the program. And I have with me Chris Andriecki, who is our Chief Litigation Consultant and all things guru. She's been an attorney for quite a while. She's been with the program forever. And we're here to, so the session is called Mock Trial. But in order to do an effective mock trial training, what we would need to do is give you a lot of information to review, and with a large group like this, it's very difficult. So what we have been doing is sort of doing a little bit of scenario stuff, and then do a question and answer. What are your challenges when you testify? Things of that nature. And then, like we're going to Gainesville in 2 weeks to do a half-day mock trial training with the volunteers because they wanted more time. And we would need a half day at least to be able to do any effective sort of mock trial training with you guys. So if you want us to do that, let us know and we'll be happy to come back and visit with you. You don't have to decide right now. You can wait till we're done and see if we answered your questions. And hopefully you'll learn something, but also have some fun this morning with this. And I have helping us out today Donnie Frenette and Camille Fraser. Probably most of you know Camille because she's been in this area for a while, and Donnie is the Northeast Regional Legal Counsel. So they may be helping us out a little bit with this. So we decided to do this a little bit differently than we've been doing it. What we're going to do is sort of a little bit of a mock trial sort of situation. Let's start with this. How many people have ever testified in court? Actually been sworn in and had to testify? Okay. And did you feel okay about that? Was it a little unnerving the first time? I'm getting nods, yes, a little unnerving. How many people have testified at a TPR trial? Okay, and we only have one mic, so by a show of hands, how many people were called by the CLS attorney or AG or somebody DCF by the department? Okay, how many people were called by the GAL attorney? Okay, so the first person who questioned you was either DCF or the GAL. Is that pretty much common? Okay, so in this scenario, Mr. Clark here was called and has already testified with the GAL attorney, Ms. Andriecki, and she asked him those questions, right? The MBI questions. Now I know Chris, I've known her for a long time. She would not ask the questions like, which we hate to see, yes and no type. Do you have an opinion as to whether or not the parent has the capacity to parent child, blah, blah, blah. Just like it says in the statute, right? Yes or no. That doesn't help the court, and it doesn't let you tell your story, which is critical. So Chris has asked all these questions. Mr. Clark here has recommended termination of parental rights. So that's where we're at. Any questions about that part? Okay. Mr. Clark, how many times have you actually seen my client with his kids?
Well, I've seen them once when they were being transported and dropped off for visitation. However, I wasn't able to stay for the actual visitation itself.
So in 7 months or so, as your testimony was, you've seen my client with his children one time?
Yes, ma'am.
And it's your position, you're trying to tell the court that that gives you enough information to terminate my client's parental rights?
Well, what I know is,
That was a yes or no.
Can you repeat the question, please?
My question, Mr. Clark, was you testified that you've been on this case for 7 months or so. Apparently you're not very clear on how long you've been on the case. And you're recommending termination of parental rights even though you've only seen my client with his kids one time. Yes or no?
Yes.
Judge, I object. This guardian has already testified previously that he's been on this case for an extended period of time. He has an awareness of the needs of the children, and he has attempted to see the parents, but they've never responded to any of his phone calls or notes that he left on their door when he went to their house to visit them. So I object to the characterization that that's all the information he has.
Your Honor, can we have counsel sworn in before she
Okay,
testifies?
let me just stop and tell you that is not a legal objection.
Right, that's not a legal
What I
objection.
just did was not a legal objection. Why did I do that? Am I helping him answer the question? Did I just do that?
Yeah.
Okay,
Yes.
okay, go ahead.
Yes. So, the point of this, I didn't have any conversation with Donnie, other than I'm gonna have you testify at a TPR trial. So, what we wanted to show, and Donnie did a good job, he was, coming up with answers. What we wanted to show you, and hopefully you haven't experienced this, if you have, I apologize, how it would feel to go into court and testify without talking to the attorney and without being prepared, especially cross-examination, right? The parent's attorney is there for one reason, and that is to damage your credibility to some extent, to weaken your recommendation to the court, to weaken your testimony, right? You guys, the volunteers, have the most information about the kids, right? You do. I mean, you see these kids more than their parents do, more than the case manager does. Foster parents also have a lot of information, and I always used to call foster parents to testify when I was a CLS attorney. When I was a parent's attorney, I wanted them out of the courtroom because they always had really good information. So you guys are also the only people in the courtroom without an agenda, right? The department, they're great people. I used to work for the department, and it's made up of really good people, but they're kind of hamstrung by policies and procedures, right? They're the most regulated agency, I would say, on the face of the earth, probably. They're looked at by everyone. So they have their job to do, parents' attorneys do. You guys are there for one reason, and that is to advocate for the best interests of the kids. So it's critical that your story come out. And before your story can come out, somebody has to prepare you to testify. So what we wanted to find out from you today, and I'll come around with the microphone, who has ever testified at anything, TPR trial or something else, and had a challenge or a barrier or something that you'd like to talk about?
I was questioned on something that was in the judicial review report to the court, and I didn't have it in front of me. And well, did you say this in the report? And I was just frustrated. I didn't have the documents in front of me to refer to make sure. And it was just like out of context.
Okay.
Which was frustrating for me. They weren't trying to get at the whole picture, just something out of context that was going to kind of make me look bad.
Right.
Or feel bad.
Okay, so yeah, the parents' attorneys will take one little sentence, right, out of your whole report and try and twist that around and make it look like either you weren't paying attention or you have some agenda against their client. Anybody else have the time they testified either didn't feel prepared or were worried about their testimony in court, felt like they got beat up by one of the other attorneys, hopefully not ours?
My situation was two older kids, 16 and 14. They've expressed a desire to go back to mom. Mom's in court. The judge delays it for 2 months, so we're going to come back and review this in 2 months. And mom is sitting there in court and says, well, I'm not coming back. So you got two kids that say, we want to go back to mom. Mom doesn't care enough about the kids to even show up in court the next time. I mean, it's frustrating. And I feel bad for the kids. You know, the kids want to go back to mom. Mom says, well, I don't really care if you come back or not.
And what was your position? Did you think the kids should be back with mom if she was going to show up?
No, I don't. She's still not. No.
Okay.
Even if she showed, I mean, she's in prison right now, or she's in jail, and you know they will bring her to the courtroom.
Right.
And she said, no, I don't really need to contemplate. She's got better things to do.
Right. And that's one of our challenges too, right? Is when the kids want to, and most kids want to go home to their parents, right? And it's not up to us necessarily to advocate for what the kids want, but what we think is in their best interest. So I know Chris is dying to comment.
I have a few comments. I really like TPRs, so let's go ahead with the backdrop of that. And I do because I believe that the time is of the essence part of this statute is very important. Our kids get damaged half of the time because they form bonds and relationships and normal parent-child relationships with placements while we're waiting for the parents to get their act together and care enough to get motivated. I don't have any tolerance for that. You know, any of us that have children know that if you took my child away, I don't care what you told me to do, I'm gonna do it like today, and I don't care what I have to admit, I don't care what kind of evaluation I have to have, I don't care how many times I have to give a urinalysis. You got my attention, I'm gonna do whatever I have to do. Okay, that's not what we're dealing with here. Your situation with your 14 and 16-year-old underscores one of the problems with being a volunteer in the program, and that is if you need a lot of warm fuzzies to feel good with a volunteer opportunity, this ain't it, because somebody's gonna be mad at you no matter what you said. So, and I train volunteers in my own circuit when I was supervising attorney in the 9th Circuit, and I train them and I tell them that, like if you are gonna feel bad if somebody's mad at you, you need to go be a candy striper or something, because this is a high intensity, high pressure situation. You have to make hard decisions. One of the other things I tell them is, if you start feeling an alignment with a grandparent or a parent, which is a natural thing, especially with little kids. I see a lot of folks that think, oh my God, that it would be so hard if somebody took my baby away. This mother must feel so bad. Okay, a lot of times they don't feel so bad. I mean, you're taking care of their kids so they can go party, and then at the end of the case plan, they'll come back around and maybe do some of the stuff. I mean, I'm just telling you.
Yep.
So, you can't project your own good parenting and your own empathy onto somebody else, because in the arena you're in dependency court, it does not resemble the way you brought up your children and the way you live and the respect you have for family and children. So you have to leave all that stuff at the door. So if you start feeling like, oh my God, I feel so bad for grandma, and I'm a grandma now, so I get that too, and I feel so bad for mom, you need to go talk to your CAM. Because our center and our focus is always the child. Everything we care about radiates from the child. And I often say this, and I'm not secretive about it. I don't really care about the parents. They only become important to me when they become positive in the life of the child. If they are not adding to the life of the child, I don't care about them. Because I don't owe these kids in our care any less than I would want from my own child. They are not worth any less than my daughter is, or my grandson, and I don't treat them like they are. So, if you get in a TPR posture, and you're starting to have any of those squirrely things about, gee, I don't know, I don't want to really hurt mom, because I've had a good relationship with mom, and she's let me in her home, and she shared a lot of stuff with me she shouldn't have said, and now I feel bad when I get on the witness stand and I'm going to say bad stuff. We need to prep you, we need to talk to you about that ahead of time, so that you don't get squirmy and not able to say what you really want to say because mom's sitting there looking at you. Have any of you had that challenge when you're testifying that you've kind of made friends with mom? Not friends, but she trusts you enough to be telling you stuff she shouldn't be telling people, and can I say Facebook? Have you ever gone on Facebook and you see stuff out and you're like going, what just happened? Do you not realize that this is, the whole universe now knows you were pole dancing? I mean, come on. Why you put that on your site, right? But the point is, your loyalty is to the child. I don't care about anything else. And if you start feeling that pull, you need to talk to your CAM and your attorney. And we'll get you ready. We'll get you ready for the hard part. And that is going to be the hard part. Tell them about notes.
Okay, I have to tell you about notes.
Notes, you got to do notes.
But first I wanted to tell you too that I used to be a guardian ad litem in Orange County, so I get it. I would tell the parents at the very beginning, I'm either going to be your best friend or your worst enemy. If you're doing what you need to do for your kids, I will go to bat for you. I'll do everything in my power. I just had a kid reunified yesterday, actually, in Orange County, or Wednesday. So I will go to bat for the parents. Chris and I disagree a little bit on this. Usually the goal is reunification, and if the parents are doing what they should be doing, I would prefer that the kids go home to the parents if they can do that safely, and the kids will be cared for. If not, I will also go to bat for the kids at all times. The kids are my focus, so I'm fine doing a TPR. What Chris wanted to talk about is notes. So how many of you, when you testified, had your notes or a file or something with you when you testified? Okay, all right, so one thing we want you to know is quit emailing and use the phone, right? Because anything you email is public record, so anything you put in an email, stupid mom wasn't home when I got there, I've seen that. The idiot dad beat the crap out of the mom again, I've seen that. So anything you put in an email is public record. Anything you put in writing is public record. So sometimes, I'm guessing, some of you have been frustrated a time or two with somebody in the system, whether it's a parent, case manager, your CAM, maybe even your attorney, although I don't think that happens very often. You're frustrated, right? You want to vent. Don't do it with a keyboard. Do it with a phone. Call your CAM, call your friend, call me, call Donnie, Camille, Jen Layton's back there, call her, she's happy to talk to people. Vent all you want on the phone, because I don't have to tell anybody what you told me on the phone. But I do have to give up anything you put in writing on discovery. Parents, attorneys get anything you put in writing. That's just the way the system works. So please, please, please be careful about that. Also, when you testify, you can make notes for yourself, because you have a pretty big file, right? You can make notes for yourself that you take into trial with you. Again, be careful what you put on there, because if you're looking at something, you're reading it, the parents' attorneys get to take it and read it also. So no editorializing, just put your observations, whatever you saw at a visit, whatever you saw, if you're aware of drug screens, if you've transported the child anywhere, you've seen the parents on Facebook or whatever. Put your observations, but don't put your opinions in paper. So how many people take notes while they're visiting a child? Yeah, it doesn't seem natural for some people. I don't even, when I'm talking to a child to prepare them for trial, I can't look at a notebook. It just doesn't feel right to me. And the kid's like, what are you writing? So, but as soon as you get to somewhere where you can safely pull out a pad of paper and a pen, then write your notes down. And again, facts and observations, right? Not opinions. Give your opinions face to face or by phone, but not in writing.
Well, yeah, and
Excuse me, I'm sorry. In the 19th Circuit, we're completely paperless, we do everything in Optima. So I just wanted to talk about that,
what she said?
So the point was, in the 19th Circuit, you're completely paperless. You do everything in Optima. Optima can still generate paper, so I appreciate that. That's a really good point. Even I learned how to use Optima when I took a case. But you still want to be careful what you put in Optima. It's discoverable. They're going to get that.
But my question is, as you got started, so when I was on the witness stand in a TPR trial, the Optima wasn't up yet. So now, if we go up on the witness stand, we can't take our computer, like we go into the courtroom with our computers, we all flip them open, we all look at them, so if we need to refer to something. But if we're called up onto the witness stand, can you take your computer with you when it's a TPR trial?
You can make your own notes.
The question is, can you take your computer with you? And Chris's answer is you can make your own notes. So
And
this will, and I'll give the microphone to Chris in a second, and I agree with what she's going to say. Well, no,
wow, now you can say anything.
and in a minute I'll give you the Powerball numbers. We've done this a few times. So one thing, and this is, and I love Optima. It's part of the oath I took when I took my job that I have to say that every time I talk to people. No, I do love Optima. I think it's a great system. But that's one thing that always bothered me about it is people are comfortable with their paper file in court with them because you can look through it, right? When somebody else is testifying, you're going, that's not true. I want to see what my notes say on this. You can have your laptop with you in court, not everybody carries a laptop, especially, you know, not all the witnesses do. And so, do you print it out and take it with you and then get dinged because you're no longer paperless? How do people feel about having a laptop? Attorneys, anybody else? How do you feel about having a laptop with you on the witness stand? You feel okay?
iPad.
Yeah, I would.
Jen's saying no. She's a supervising attorney. What's the problem with having a laptop on the witness stand?
Well, my concern is that whatever's on the laptop is whatever the witness is looking at can be seen by anyone.
Yeah.
And I'm not sure that there's a limitation that it's only what's on that particular screen
Right.
that would be visible to everyone. If the laptop is there and there's program open, I would be worried that there would be more on that program that would have to be shown to the other parties than what's actually just on that screen.
Especially if somebody's trying to act like it's contextual, so you wanna go, well, but that was only your note there, what about when you went the other times? I mean, I don't think it's a good idea, and granted, I'm old, so that could be that, I like paper and handwriting, but not for the editorial notes we just talked about, because I've had to give those up too many times where somebody wrote in there, boy, these parents suck so bad. I can't believe anybody let them have children. They should be like castrated in their uterus. I just had to give that to defense counsel. Why do I have to do that? And the bad part with it is not that you're not correct. I totally agree with you. I have offered to do castrations in my office. Nobody did that. And I can do them. I've done it with dogs and cats and horses, but that's a different issue. The problem is that it makes us look biased now, which means we come in there with a negative opinion against the parents, as opposed to we come in there with an open mind and our child advocacy is our focus, and that with a reasoned opinion and a lot of experience in this case, we've come to the conclusion that it's not in the best interest of the kids to be in the custody of the parents. Not that we hate the parents, therefore the kids shouldn't go home. You see the distinction? Because all we have is our rep. We don't have anything else. We don't have money. You know, we don't have the ability to sign everybody up for stuff and do things and move them and place them, and we don't have that. All we have is our reputation of the court, and if it looks like we're biased against somebody, we just lost the only thing we have, right?
Okay, we have a few points here. I'm okay if you're biased. Be biased toward the kid.
I was just gonna say, I'm from the 18th Circuit Court, and I was told not to bring notes on there, but what they told us to do is make a timeline of everything that happened in the case, and it kind of was a really good way for me to review the whole case before I got up there. And then it would just be just facts, you know, this date there was a hearing, the father didn't show, and then this date, you know, he stopped visitation, you know, so that really helped me even organize it in my mind, and I ended up not needing to look at the notes.
Yeah, that's a good point. And I
You
used
should do that
to,
anyway.
I used to tell people to make a timeline as well, but
Yeah, you should do that anyway, because how many of our cases are like 3 months long? I would be none of them. You know, all your cases are gonna be beyond the length of your case plan, so it's gonna be at least a year. So timeline helps you focus about, gee, when did that happen? And it will also trigger you to go look up other stuff. If you don't remember, you'll realize you don't remember something before you get on the witness stand. So the timeline's an excellent idea.
What about text messages, text strings, text conversations?
yes, those come in as well. That's why I try never to use my personal cell phone for work purposes, because I get venting from people as well on my work phone. And you know, if I had to turn that over, it probably wouldn't look good. But
I was just going to say, if you're using Optima, if you put in your notes, in my opinion, or this is what I observed, then you're not going to look like you're prejudiced one way or the other.
Depends on what your opinion is.
no, that's perfectly okay. And I want your opinion. If I'm in court, I'm going to get your opinion. I'm going to ask, for instance, if we're at a termination of parental rights, I would ask you, what is your recommendation? That would probably be my first question. What is your recommendation to the court on termination of the parent's parental rights? and you hopefully say, because we're at TPR, that I think the right should be terminated, and then I'll ask why. What's the basis of your opinion? And let you tell me. And, you know, and I appreciate, Kathy, I appreciate the attorneys, I'm assuming, was it the attorney or the CAM that told you to do a timeline? The attorney. Tell you to do a timeline. I think that's a great idea. Chris and I have talked about that. I used to tell case managers too, because, you know, you've seen them come and they have a milk crate with 14 file folders in it. You know, it's painful to watch them go through it and ask them a question. So, first of all, when the attorney's preparing you for trials, which should be happening, if it's not, if you're going to testify and you haven't talked to the attorney yet, please call them. If they don't answer, call the supervising attorney, call the regional legal, which in this case is Camille for most of you, or Donnie for if you're in the 18th. Make sure that you talk to somebody so you're comfortable, because a timeline's great, but guess what? I'm the parent's attorney. I'm going to ask you stuff that's not on your timeline, and you're going to need to know that. So I don't know what the answer is with regard to Optima. That was a great question. Some courthouses have computers up on the witness stand and at the tables. So you could probably access what you need to, although I don't know with our Citrix and our firewalls and all that if you get in there, but it would make me nervous to not have something with me I could look at while I'm testifying. I have testified a few times. One here and then I'll be right back.
I just want to say that I've been doing 7 years, so I was prior to Optima and everything else, and when we're in St. Lucie County, small little room basically. So, and I'm also a nurse, so I'm very particular about just the facts and everything, which I think from what the woman from 18th Circuit said, just a little timeline note has worked from then, and it still works now, because no matter what, I am nervous when someone asks me questions in court, and I've gone multiple times, unfortunately, but that's the best thing. And I think having a laptop open, especially on a witness stand, just looks, I don't know, rude. And I'm always afraid someone's going to ask for other things that are on my laptop or my phone, texting and so forth. But to me, that's the best thing, to do the notes. So then if they say, hey, we want to see that, it's just the facts. It's everything from, because again, they are over a year, a couple of years. And even if they've had several different caseworkers, which is what I find, their answers are, I'll say, wrong because they're different. They weren't there from the beginning, and then I say no on this date, blah, blah, blah. So that, I think, just from my personal experience, works best.
Thank you, I appreciate that. And yeah, I agree. I have to have something with me to look at if somebody asks me a question, even if I have it on the top of my head. And hopefully you've been prepared for court, and so you are able to answer the questions that aren't on your notes or timeline.
Yeah. When I was up on witness stand, I'm pretty sure I wasn't allowed to have anything. I remember that. You had to ask. And I just didn't take anything. I was very prepared in my head about it then. But I love Optima, and it's really easy to navigate. So if I'm allowed to have it, that's what I was wondering, am I allowed, or is it up to the judge at that moment, that day? Because if someone were to ask me a question, I know exactly where the answer would be in Optima.
Mm-hmm.
Whereas, like you say, shifting through files, it would be difficult.
Right.
And that's a really good point. And the technology is starting to catch up to the court system. I think, we're about to 1995 or so. But I agree, I think Optima is great. You can find anything you want in there. I don't know, some judges are gonna say no. If they can't, was it Judge Shack?
Judge Shack, the one he had a piece of paper.
Right,
Yeah.
right, that's what I meant.
But I don't know about Judge Heisey.
Okay. And some judges don't want you to have anything up there, but you're right too, as far as you have to ask, and that's a really good point. Chris will tell you what to do if you don't remember something and how you do that.
Well, and I wanted to get back to the point you made about somebody was asking you about some little snippet out of a document. If the attorney with you could have easily said, Judge, he needs to have the document. If they're going to cross-examine him on a document, they need to give him the document. And make enough of an issue about that that you should have been able to have that and not felt backed into a corner. So I mean, a lot of that has to do with if sometimes you anticipate what you're gonna get skewered on, so you're ready, other times you don't. But there could have been enough hay made about that, sometimes they even forget what they're asking you if we're obnoxious enough. Right? Just saying, I do a little bit of that sometimes. But,
There's a lot of amnesia in the courtroom she's in, I'm just saying.
yeah, just saying, that happens. Now, one thing that I note that Kelly was talking about the refreshing the recollection, and we'll talk about that in a minute, but I don't want this to be done before I tell you this, and I almost want you to write it down, although it'll start to look weird if you all say exactly the same thing when you're asked the question across the entire state of Florida, that it sort of rises into the atmosphere. When you are getting cross-examined about, oh, why didn't you go see the parents? Or why didn't you call the grandparents if they could have been a placement? Or why didn't you, talk to auntie or cousin or something if you've been on the case this long, why didn't you reach out to all those people? The answer to that question is, it is not our job, and your job specifically, to make anybody look more interested in this child than they really are. Now, if you're a grandparent or you're a parent, hey, your phone number's the same all the time. The guardian's phone number's right on the card. The guardian's phone number's right on all the court paperwork. You can get the guardian's phone number by calling the judge's JA, right? So if somebody wanted to talk to you about this child, all they had to do was pick up the thing and call you. It is not your job to try to generate interest that isn't even real and that's not motivated from the right place. So the answer to the question is, it's not my job as a GAL to try to make people more interested in Johnny than they really are. And that includes the parents. You're not supposed to have to go throw a net and drag them in there, right? If they're interested and they need to talk to you, they'll talk to you. Now, having said that, we get a lot of good stuff from making the effort to talk to parents because they say stuff that they shouldn't be saying. I mean, you can hit pay dirt like almost every time. I mean, it can either be good stuff that they're friendly to you, or they can be calling you names. I can't even tell you how many names, so you probably know, that either I or the CAMs or the volunteers have been called, heck, in the courtroom, or right outside in the hall. I mean, I've had fathers walk behind me and threaten to kill me on the way out of the courtroom. I mean, it's awesome, because then you just put it on the record. Judge, I'd like the record to reflect that, Mr. Herrick just said he was going to kill me after court. And then, the record so noted, okay, that's all I need to know. Just get it on there. Because the things that they say are an indicator about the people that they are, and it helps you assess how safe a child can be, and not just safe physically, but, and this is another thing that we don't look at enough, and sometimes the department didn't do it. Neglect is as bad as abuse. You can get TPR'd for having a dirty house over and over and over again. Why? Because you're telling the kid every single day, you're not really worth my reading to you, or taking you to school, or bathing you, or teaching you how to brush your teeth. Yeah, you're not worth it for me to take you to the dentist, really. And actually, it isn't, you're not worth it for me to get the dog feces out of the living room. You're really not. So, hitting a kid is one thing, and it's bad. Sending a message to a child every single day of their life that they have no value for you to do anything creates the exact thing you're trying to take them out of, right? And I can and I have terminated parental rights because of dirty houses. So don't always think it has to be something really horrendous, because chronic neglect is really horrendous. You're sending a message. The kid can't help but get the message that they're worthless if you give it to them every single day, right? So if you have cases that you have concerns about or you're alarmed about, you need to go to your CAM and you need to go to your lawyer, because when we look at cases that might wind up being TPR, we need to start laying the landmines early. And we need to start setting it up and be ready, because we can make that case much stronger for the court to be able to see the conditions the child is in if we know on the front end, instead of we get to the back end and go, gee, I wish I'd really checked to see if mom was going to NA. or something.
And this is the part where, you know, I want to reiterate again. No, that your opinion, your position, your point of view is critical. So that's why Chris is saying, if you have a case, you're concerned about the child, you don't think the system is moving in the right direction, whatever, whichever way it is, because I'm okay with reunification too. Chris wants to terminate rights at shelter, but she would if she could.
I would.
But if the case isn't going in the right direction, please let the CAM know, let your attorney know, and we'll sit and talk with you about it. My position is, and mine's the only one that counts because I'm the statewide director of legal services, what the attorney's job is to get the kid where you think the kid needs to be. Okay, so you do the best interest analysis. You spend time with the child, sometimes the parents, the custodian, the teachers, you go to the IEP meetings, you go to doctor's appointments. I mean, you have all the information. That's critical. It's critical that we know it so we can present it to the court. Because I can tell you, I've been doing child welfare for 20 years, and I've never heard one judge say, this case went wrong because I had way too much information, right? Never, never, never. So don't be afraid to let us know what's going on, and don't be afraid when you're in court to give your opinion, especially JR, right? At JR, anything goes for the most part, depending who your judge is. You should be able to say anything you want at a JR. Hearsay comes in, you should be able to talk about, you know, your concerns for the child, of course respectfully and not name calling. But it's critical for the court to have your piece of the information, because you have more information than anybody else does. So if you're not, you know, feeling like you're being heard, like your best interest analysis is we're not following that track, please let us know. Sometimes the answer from the attorney is, we can't get there right now from here, but we'll tell you how to do that. We'll give you a roadmap, we'll tell you what we need to get the kid where the kid needs to be, from your perspective.
I have a question about the client-attorney relationship as it relates to like a mom. And I saw this first when I was being trained to be a guardian, and it frustrated me. I thought, is this the way the system works? You see a mom and she's totally messed up, but the attorney will stand up and say, Judge, we request that the case be closed and mom be reunited with the kids. And I'm looking at it and I said, how can you request that? This mom isn't ready. Now, is an attorney required, if the mom says, I want to be reunited, to request it? Or can that attorney say, no, you're not ready? I mean, to me, it was so frustrating to watch this take place.
That's kind of a yes and no. Attorneys have to advocate for what their client wants. That's why you'll see differences with attorney ad litem's for kids. They have to advocate for the child's stated interest, not best interest. So that's where we differ. You have to have some client control. I used to represent parents, and right around this time of year, actually about the beginning of December, they would call me and say, well, I never heard from them the rest of the year, but they'd call me the beginning of December and say, you know, it's almost Christmas. God, no thanks. You don't know when your court date is, but you're calling and working my calendar now. What can I do for you? Well, I want my kids home for Christmas. Oh, cool, I'll just make a call, we'll get them home. No, your study's in crack. You haven't done your psych eval. I'm not getting your kids home. And I'm not going to ask the court, because you do have to ask in good faith. What you can say is, and I've done this, and I moved several steps to the right, Judge, my client would like to address the court. She thinks she should have her kids back now, because she didn't drink yet today. I don't know, whatever the story might be. So I cannot in good faith make the argument on behalf of my client, but that's what my client wants you to know, is that she wants her kids back.
Why does it take so long to get to TPR?
That's a very good question. Anybody didn't hear that? Why does it take so long to get to TPR? There are many reasons for that. I think sometimes at the very beginning we're not identifying cases that should go what I call expedited TPR. It doesn't have to be egregious abuse, that's where you usually see it. But I've done cases where it's mom's 10th crack baby, and she's lost her rights to the other 9, and she's still doing the same thing. Really? We're giving her a case plan? For what purpose? I mean, you know, we're wasting that 50-page document, 74 copies of it, by the way, that get disseminated in court. Why? I mean, I think we need to first get better about identifying, and if we're actually gonna reunify, then we need to get better at doing that quickly too. Let's get moving.
Well,
Why have we have every parent going to parenting class. They're drooling, using drugs, mental health issues. We don't address that first. We send them to parenting class. What are they getting out of that parenting class? Nothing. They're finding friends to use with. That's what they're doing.
you know, the statute says that the maximum length a case plan can be is 12 months. It doesn't say a case plan has to be 12 months.
Correct.
I do case plans that have drop dead dates at, say, 90 days. If you aren't substantially along in your case plan tasks, this case plan turns into an adoption, a goal of adoption. Or maybe you give them 6 months if it's substance abuse treatment and they're gonna go inpatient or something, you give them time to do it. If we're at 6 months and they haven't started anything, you can put in a case plan that if you have not begun substantial compliance with your case plan by 6 months, that's it. You don't get another 6 months to screw around and see if perhaps you're gonna get moved, maybe to show up for your psych eval. And then, when you get to the 12 months of your case plan, they say, well, Judge, my client just started treatment. I mean, we need to give her an opportunity to have her therapy before.
And it's in the statute too, right?
It is really in the statute.
Material breach. So if you have a client, if you have a parent who has been using substances for 10 years, and it's 3 months into the case plan, and they haven't even started they haven't done their substance abuse evaluation, and guess what? They've left the county, they've moved somewhere else, probably because there's a warrant, and I'm not trashing parents either, but they move a lot, right? Because there's warrants or there's some other opportunity somewhere, whatever. To me, that's material breach. The goal is reunification. You can't even visit anymore because you left the county. How can we, to me, a case plan's a contract, right? So the parent's job is to do these tasks, and guess what? Not just check them off, but what's the point of the tasks? To make them able to safely change their behavior, right? Safely parent their kids. That's their part of the contract. Our part is, then we'll put your kid back with you. I can't even start to perform my end of the contract unless they do theirs. And guess what? Moving out of state and using drugs make it impossible for me to do my part of it. So to me, that's material breach. I've filed material breach TPRs for years.
Yeah, all day long.
Been very successful with those. So you're right. One of the biggest problems, I think, are incarcerated parents, right? Because that terrifies the department. They won't terminate parental rights. I used to tell my clients, go clean up your warrants, go to jail. They won't terminate your parental rights. They're terrified. So we do it now. We do it all over the state. The Guardian program has been filing a lot of TPR petitions. We adopt the departments if they dismiss them. Sometimes they dismiss them at advisory day of trial, and we'll adopt it and we'll prosecute it. So we can do that. If you have a case that you think needs to be going TPR and it's not, the statute says the department shall file after
Yes.
398055.
It requires them to do it.
Requires them to file a TPR, except there's like 4 or 5 exceptions. My favorite one is, except we didn't do our job, and so now we can't file a TPR. And they never say that. That's never their reason they give the court. But we have the ability to file TPRs. We have litigation funds. We can subpoena people. So please, if you have a case, I do crazy case staffing, so do these guys. Let us know. We'll be happy to staff the case with you and try to get it moved towards permanency.
Well, and that also
Christmas,
underscores the importance of the judicial reviews. Because I know it's tempting to just get reams of paper from the department with their JR report, and you can't even find anything in there to see that's actually factual, that's not the big boilerplate thing that sometimes they have the right stuff in it. Sometimes it's actually stuff from another case because they just cut and pasted, okay? But what is important in there is that the judge makes findings at judicial reviews about the level of compliance with the case plan of each parent. So if the judge is saying, oh, they're in substantial compliance, and they're not, we need to be setting our hair on fire and going, wait a minute, that it is not substantial compliance when mom just threw dirty UAs 2 weeks ago. Or, it's not substantial compliance when mom is still going to the methadone clinic and she hasn't even titrated down off of the methadone. Because guess what? If you're on methadone, you're not clean and sober. You just have a different drug instead of your heroin. It is not clean and sober. Don't let the department tell you, if you're using methadone so you don't have to go buy heroin, that everything's good and you get your kid back. And we don't play that. That is not clean and sober. So, when you go looking at the JRs and you get them, you really have to look at where the department is trying to say somebody's in compliance. Because it can be the kiss of death later to your TPR petition, because defense counsel say, no, they can't file a TPR. Judge, you made a finding they're in substantial compliance. And then what do we stand up and say? Well, that's just because we didn't read the JR, Judge. Otherwise, we would have objected. Now, that's really not the answer we want to give in court, probably. I'm just saying, right?
Even if it's true, because I've had.
I've had a lot of judges tell me they look
They
at
don't
our
read them either.
report, they look at your report
Yes.
before they look at the JR from the department, just because it is so many pages and it's got so many things you gotta go through. But one point I wanted to just follow up with what Chris just said, be really, really, really careful when you even say substantial compliance, because that's a defined term. That means the situation has been remedied and the children go home. So if the parent is actually in substantial compliance, great, say it out loud, and let the kids go home with them if that's what you think should be happening. However, don't say it unless you think that's where we're at. And like Chris said, we need to review the orders very carefully. I've seen orders that say the parent is in non-compliance, parent has done nothing on their case plan, and then the judge checks the next box, which is reunification that's likely to occur within 12 months. What?
Yeah, not so much.
And we're in month 11 and they haven't done anything. No.
Exactly.
So, right.
But
So
what do you do if the judge continues to extend? We have cases that are years.
we can appeal
Because
it.
they continue
Well,
to
and
extend.
they're not even supposed to be doing that under the statute. But
Right,
you
the
have
question
to-
is, what if the court continues to extend? And I can tell you, they rewrite the statute every year, and every year they make that language a little bit stronger, right? No, seriously, a year. That's
Yeah,
all.
we mean it this year.
Yep, this year we're really gonna hold your feet to the fire. You get 1 year, that's all you get. But it doesn't happen, right? I mean, that's not our reality. So what we can do is appeal the judge's ruling.
Put
We've
our
done that.
objection on the record.
Yes, put your objection on the record. Judge, you're not allowed to extend a case plan. It says so in the statute. Put the objection on the record, and if the court does it anyway, we can appeal that. And we have, those are the cases where we've filed termination of parental rights petitions, because it's 14 months.
Well,
It's, what the heck, 37 months. I mean,
We-
years, yes.
We file them even when it says substantial compliance, because it is not the ideal way to do a TPR. Like, remember that stuff you said, Judge, about substantial compliance? Well, you were full of crap. We're gonna file one anyway. I mean, it's not the ideal really way to taxi onto the runway to take off on your TPR, but hey, if you gotta do it, you gotta do it, right? The other thing that is a really big deal about dependency court is that it is not a vending machine. You do not show up at your tasks, you get your certificates, you show up in court, you shove them into the vending machine, then your kid comes out the bottom. The certificates have nothing to do with anything except that somebody, maybe you, attended and maybe got a certificate. That does not mean that the reasons for removal of the children got remedied. That does not mean that. I've got TPRs all day long with people with so many certificates you can't see over them. If their behavior doesn't change, if their attitude and commitment to their children doesn't change, if they're still doing, like if they go to a substance abuse class, they get a certificate, and then they throw dirty afterwards, you might as well set that certificate on fire, right? Because they learned nothing.
With your hair.
Yes, your hair and the certificate.
A lot of fires going.
That's right. So don't let, because sometimes DCF tries to, or Parents Council, bully us a little bit. Well, they've done all their stuff. You know what? That is meaningless to me, because you aren't acting like a parent.
I had a guy in court one time, he was my client, unfortunately, and he said, Judge, I already did the GED anger management class. I mean, a big difference in this life.
How do you feel, or how do you handle permanent guardianship versus TPR?
Don't like it usually.
That's shocking.
Because I have the parent that's not done anything, we're in, next month is the 11th month, and
How old is the kid?
13.
See, the age of the kid can sometimes make a difference,
Right.
because if the kid has an established relationship with a parent, and they're gonna have some tangential interaction with the parent, and because they're old enough that the parent can't really screw them up as much and they're in a good place, maybe.
She's
Let me-
with a grandmother and she's seeing.
Yeah, that's normally when it happens,
See,
because
I
the
used to-
grandmother doesn't wanna cut them off at the knee.
Right, I used to tell my clients, it's all right, your rights are gonna be terminated, but now you need a sibling to your child, because grandma's adopting, right? Now you're the sister.
Yeah.
You're not giving,
Closer now, 'cause it's saying
you're siblings, you're not giving anything up. I think there's a place for permanent guardianships. We used to use them historically because grandmas couldn't adopt because they had a 1972 pot arrest, which always killed me.
Right.
So we used them because they wouldn't pass an adoptive home
Right.
study. That's how I usually used them. However, so the first goal is reunification. That's what we're all working for. The statute says so. That's the priority. There's a Supreme Court case that just came out and reiterated it. Number two, except Chris, number two is adoption. And
Yes.
before you get to permanent guardianship, the court has to find reunification isn't gonna happen in a year or 7 years, in 1 year, that adoption is not in the child's best interest. That's a critical required finding. Unless the court finds that adoption is not in the child's best interest, and we don't go to number 3. That's how the statute says it's supposed to be. That is how it's supposed to be. But sometimes it's the path of least resistance. It's easier to go permanent guardianship. Parents' attorneys will come in all the time and say, hey, we agree to permanent guardianship. Well, the child's 7 months old. No,
Yeah.
it doesn't make any sense. Because guess what they're not? They're not permanent. They're really not guardianships. They're not a 744. They go away for 6 months, and then I can't tell you how many cases we found mom has the kids back.
Well, and I've had them where parents have said, well, can you just do PG for a couple of years until I get clean and sober, and then, when I'm done, when I get all done with this drugging thing and stuff, and then I'll come back and get them. I'm not going, not really, no, I don't think we're doing that. But
It's parent life, we call it.
yeah, it isn't even, if you look at the statute, and sometimes what they'll throw is least restrictive means. It'd take us 3 days to even go through least restrictive means, which is terminology, terms of art in the statute, that the court's required to make a finding of least restrictive means. And so what a lot of times the parents' attorneys will say, well, adoption's not the least restrictive means, placing them with a relative is least restrictive means. Well, first of all, I won't even go into my opinion about relative placements, because a lot of times they circle the wagons, you can't get information, you're blocked off, and you're not getting a real scoop on what's going on with the kids. A lot of times, not always. But they need to be looked at with a different eye, because you have to figure out if you're getting worked or not. Or if it's really permanent guardianship, a lot of times is just another name for reunification behind our back. Okay? Like, we're going to the grandparents, but then mom moves into the house, then mom takes off the kids. So you have to look at it, with a critical eye. But the least restrictive means argument has nothing to do with that. So don't let somebody tell you that TPR isn't least restrictive means, because Kelly's exactly right. If you can't safely reunify, the next preferred resolution for permanency in a case per the statute is adoption.
We have to wrap up.
We're going to wrap up.
Yes, we have to wrap up so everybody can go have lunch. Any last questions or comments? We would love to come and hang out with you guys in your respective circuits.
Can you
And
be my attorney, please?
Yes.
Globally, we are your attorney.
Yes, we get asked to come do TPRs.
Yeah, and I'm all about it. You line them up.
Yeah.
Because I like it.
Yes.
I do.
Thank you all for what you do. Seriously, I mean, your information is so critical. Don't make anybody make you feel mad about you giving your position to the court. The court likes to hear from you. I can't tell you how many judges have told me they really, really rely on the guardian because you don't have an agenda. You're just there for the kid.
Well, and
So
usually
please.
we're the one that's been on the case the longest. How many dependency case managers have been on the case during the period of time that you've been assigned to a child? Usually, we are the stability and the consistency in the case more than anybody, even the judge. A lot of times cases will go to different judges, different attorneys, different whatever. So you are so important in that process.
Believe it, give it as a
What
count.
No, I just wondered if you'd just give us the statute again, the statute number.
39.8055. Thanks.
Thank you.
Thank you.